Okay, everybody, welcome to How to Comply with Michigan's Earned Sick Time Act, or ESTA. We're very fortunate today to have Mike Blum from Foster Swift, Collins and Smith, with us to present on this and share his great wisdom. Mike is with Foster Swift's Labor and Employment section, so I'm going to go ahead and turn it over to him.
Okay, thanks,
You're
Claire.
welcome.
And thank you to the Library of Michigan for sponsoring this webinar. I know that after many, many months, if not years, of anticipating for this law to become effective, there were numerous last minute changes made the night before the ESTA was to take effect. And that was House Bill HB 4002 that had been pending for quite some time, but it made it to about midnight and then finally got passed. So that was the bill that amended ESTA and was sent to the governor and signed it the next day after it actually became effective before the governor got it and signed it. But that's why we're where we're at. And unfortunately, because of the way this developed and the last minute changes, there remain some gray areas that everybody, including the Michigan Wage and Hour Division, is still trying to sort out. So I can't say that every single piece of ESTA is now firmly well known. It's not. But what we're going to try to do today is summarize the changes that were made that became ESTA as we now must comply with and answer as many questions as possible in the time we have today. So with that, let's just jump in. Those the first next slide, Claire, and we'll go through some of the details that we need to know to comply. We start with the effective date. There's a number of different effective dates in the final version of ESTA. For small businesses, small libraries, in the ESTA, they call them small employers. It's effective October 1st of this year. So for small employers, ESTA is not yet effective. The small employer is an employer or a library that does not have 10 more than 10 employees. So ESTA says 10 or fewer employees. But there's a caveat to that, and that is that you have to look back 2 years. So if the library employed 11 or more employees in 20 or more weeks in the current or preceding year, it cannot be considered a small employer. So as we go forward, if you hit 11 employees as a library for 20 weeks, you must comply with ESTA for at least 2 years because there's always this 2 year look back period. So you got to take a look at not just a snap in time on the 10 or fewer employees, you got to look at the history. For new small employers, there's something, this was new in the final version that came in at the last minute. But if a library did not employ any employees, and I don't think too many, you're not going to see this with libraries, it's primarily for the small employers, but I'll just throw it out there just so that everybody knows in case it might fit. But if there were no employees as of February 21st of 2022, the employer does not have to comply with ESTA until 3 years after they hire their first employee. So you may hear some discussion, or on the internet, you might hear some chatter, if you will, about complying with 3 years. That's what it's about. It's got to be a new employer that did not have any employees as of February 21st, 2022. It takes 3 years before they have to come into compliance. So those are the exceptions to the general rule. The general rule is all other employers had to come into compliance with ESTA as of February 21st, 2025. So that's a couple of weeks ago. Um, so the issue with complying, what is the agency or the wage and hour division looking for compliance? You have to start accruing if you're on the accrual or front loading as of February 21st. So you had to start accruing as of February 21st, or if you're front loading, we'll talk about this in a little more detail, but it has to be retroactive to February 21st to be in compliance. You also have an obligation to post a notice. There's a mandatory notice that was prepared by the Wage and Hour Division. And the initial draft of it that was up on their website had some errors in it. So if you posted that notice before March 7th, it's probably outdated and has errors in it. The updated notice is dated March 7th. I have a link to it on the last or second to last slide. So you'll see that. You can also go into the Wage and Hour Division's website, and they have put the correct, they've updated it and put the correct notice in there. So again, you need to make sure that the notice you have posted is dated March 7th and that it is up by March 23rd. And that's what the Wage and Hour Division is really going to be looking at for good faith compliance. Now, anything outside of that notice, you also have to advise employees of. That's where the policy comes in. The policy is not necessarily required, but if you want to do anything different than the just the information in the notice, you should have a policy that is also provided to all employees. And that's what most libraries that I've been getting calls from and working with are working on the policies. So those policies, if you have already have them, that's great. If not, you should make them retroactive to February 21st. So with that, um, that gets us to the accrual and usage cap. And the accrual and usage cap creates some issues, I think, is some misunderstanding as to the 72-hour and 40-hour rule. Under for small businesses, for accrual, it's 1 hour of sick time for every 30 hours worked. But where the 40-hour comes in, as a small employer, is not required to allow employees to use any more than 40 hours in a year. For all others, those with 11 or more employees, it's also 1 hour for every 30 hours worked. But those employers, the larger employers, are not the limit to usage must be 72 hours. So I have seen some policies or had some discussions or some questions or some calls on limiting accrual to 40 hours or 72 hours. That's not the way ESTA works. ESTA says if you accrue it, it's 1 hour for every 30 hours worked without capping. What you can cap is the usage, either to 40 or 72, depending on your size. Now, with the accrual, the 1 hour for every 30 hours worked, one of the issues comes up, what if you're salaried exempt? Because you don't have to keep track of hours worked. And so how do you figure out how many hours they accrue? And the statute clarified that, and they say that for salaried exempt employees, they are assumed to work 40 hours a week unless their normal work week is less than 40. So you could have some library directors, or their normal schedule is 40. Some might be 35. I've seen a lot actually at 35. Whatever the normal hours for accrual is, that's what you use for the 1 hour of sick time for every 30 hours. It would be for everything in the normal schedule for the salaried exempt employees. Now, another issue that I've recently been seeing, And I think this comes up a lot where you have on-call employees, and I don't know how many libraries actually have on-call employees. A lot of municipalities do. But there's an issue of how do you use the time? What can you use them for? And this wage and hour division, most recent FAQs clarified that. They said that it's only for scheduled work hours. Employees may use sick time for only scheduled work hours. So if you have um, on-call employees or somebody without a normal schedule might come in once in a while, they cannot use that to accrue sick time. They can only use accrued sick time for their normally scheduled hours. And so again, it's a little nuanced. It may come up. I thought you should be aware of it. It's relatively new in the last FAQs. Uh,
Hey,
the
Mike,
other thing is, yep,
there is a question in the chat that's germane to that. Um,
okay.
so
Yeah,
there
I'll
are
rely on you to watch
there
the chat.
yeah, that's fine. There are many libraries that have like substitutes. So they're library staff that are called in to work when, say, a reference librarian is sick, and so they're called in only to work when someone is sick and can't work. Um, so if you have employees that that's their only job, they are just substitutes. They're only called in when necessary. Um, so do they actually have to accrue time, or if they choose their own hours? Are they under, if there's a policy where, they can choose their own hours and they don't get punished if they don't pick hours, are they under that exemption too? So they don't have to accrue hours at all, in addition to not being able to earn them for, like if that's your only job to come in when someone else is sick, if you can't accrue time during that, then does that mean you don't get time at all?
Yeah, and we're going to talk about this in a little more detail when we
Okay.
get to the
Okay.
next slide on the exceptions that were put into the final version. That's where the exception of employees that schedule their own hours comes in. So I want to talk about
Okay.
that
No
in
worries.
a little bit more detail later. But for our purposes at the moment, that's a very limited exception, and it would not apply in the situation you just mentioned or this
Okay.
question mentions. So the answer is the substitutes would be required to accrue time when they're called in, they're working in the interest of the library, they would be an employee. So they would, after 30 hours, get 1 hour of sick time in their sick bank.
Okay.
And so once they get that, they could use it. The question comes in, how do they use it? And can they wait till a job comes up and then say, well, I don't want to take it, but I want to get paid? No. That I think this is what the wage and hour division was saying. Is you cannot you cannot accrue the time, and then even if you're not scheduled to work, get paid anyways. What you would do though is if you have an hour in your sick bank and then the job becomes available and the individual says, yes, I'll take it. And so they're put on the schedule. But then by the time that moment comes when they're supposed to show up for work, they get sick. In that situation, they would be able to use the sick time. So if once they are scheduled, if they after that cannot work because they get sick, they'd be able to use accrued sick time. Anything else while we're paused here?
Okay. Um, there's one more question. I have a part-time employee who gets 3 weeks of vacation. Can I now consider this PTO and her sick time can come out of those 3 weeks if she chooses to take it?
Say that again because there's a nuance here. I want to make sure I have it right.
I have a part-time employee who gets 3 weeks of vacation. Can I now consider this paid time off and her sick time can come out of those 3 weeks if she chooses to take it? So if they're giving her 3 weeks of vacation, can the library change that vacation to be PTO, combined sick and vacation and
Okay.
satisfy the um, ESTA requirement?
Right. Okay. And the reason I took a step back to make sure I understood it, and here's another nuance. The answer to can you combine it? The answer is yes. And that's also something that's on a another slide. But you can combine them. You do not have to provide sick time, 72 hours or 40 hours on top of other leave. So a combined PTO is fine. But the reason why I hesitated is because it's when you provide it, the PTO time in this year. And the a lot of businesses, libraries, and all other businesses operate either on a fiscal year or a calendar year. So they didn't wait to see how much time to provide to see what the legislature was going to do on February 21st. So let's use, for example, the calendar year. And so the employer gave employees 80 hours by way of example, January 1st. The question becomes what happens February 21st? And if the answer is if that 80 hours, if some of it was used, you cannot consider any time that was used out of that bank between February 1st or January 1st and February 21st towards ESTA. If it was not used, then it can. So, just for the example, to try and make this a little bit clearer, 80 hours put into the bank January 1st. Let's assume employee A doesn't use any of the time. February 21st comes along, in that bank is still 80 hours. ESTA requires 72 hours. You're in compliance. The fact that you put it in the bank January 1st is fine because it's still there. Now let's look at employee B. They use 40 hours of that 80 in January or early February. February 21st comes along, they only have 40 hours in that bank. They are not in compliance with ESTA because ESTA says 72 hours. So that employer would have to put an additional 32 hours into the bank to come up to 72, even though they had previously provided 80. So you don't have to provide a new 72, but as of February 21st, that PTO bank has to have at least 72 hours in it for available for the remainder of the year. And it can be, and I see also, what year. You can use any 12-month period. A lot of libraries are on fiscal year. If you're on calendar year, you would take it from February 21st to December 31st, which I think is 62 hours prorated. Um, if you have a fiscal year ending June 30th, you would take the amount of time they would accrue from February 21st to June 30th. And then on the prorated, that's what's got to be in that bank. So that's how that works. And there's a FAQ that was, I think, amended in the last day or two that added this as a specific example. Okay, so let's move along. Some of these as we go some of the questions might be covered.
Hmm.
Actually, go back to the prior slide. We're about halfway through, I think. We're talking about the accrual and the usage.
Ah,
Um, and then we talked about the scheduled. So what this gets us to is the carryover. And the carryover is another area that was changed at the last second. Uh, the ESTA had no cap on carryover. It wasn't permitted. The original HB 4002 would have not required carryover at all. What the final version compromised that, and they said there's new cap on the carryover that was put in. So the carryover is either 72 for most employers or 40 hours for small employers. So if you have accrued time, again, accrued time, whatever they accrue uh, throughout the year, at the end of the year for the unused, whatever they did not use, they can carry over for small employers 40 hours uh, or regular employees 72 hours. So, where if you step back and you look at this, and I think this puts into perspective the confusion between accrual and use, is you can't cap accrual. So, come 10 years down the road or whatever, you might have 100 hours in the bank for the employees that never use it, but you can cap how much they can use in 1 year, 72 or 40, depending on the size. So you can cap how much they can use, and you can also cap how much they can carry over. So for the regular employer, you can say you can only use 72 in a year. And then if you still have another 72 in the bank, you can carry that over, but you can't cap the total amount that's accrued. So if you take a snapshot in time, there might be more than 72 in the bank, and that you have to permit. So how do you stop carryover under the revised law? You front load. The front loading benefits under the what became ESTA law that we're dealing with now. If you front load, and front loading means that you put in 72 hours at the beginning of the benefit year. So and it has to be made available immediately. But if you front load it, then there is no requirement to track time for accrual, and there's no requirement to carry over. So that's one of the benefits of front loading. Front loading for part-time employees is a little trickier because the part-time, the ESTA says 72 hours, but part-time doesn't work 72 hours. How do you front load for part-time? The final version of ESTA specifically addresses this, and there's three pieces to it. One is you have to provide the part-time employee with written notice of how many hours they're expected to work during the year. And then you have to front load based on the expected hours what they would accrue under the accrual system for those expected hours worked. So if it's 50, if it's 50% employee, normally you'd work 40, now you're working 20, you're expected to work 20, then you front load half of the 72. So you front load 36 hours, you put that in, and that is permissible. But you also have to track now how many hours are worked, because if that person you estimated at 20 hours works some extra time, and they in fact work 25 hours, that last 5 hours is going to be considered as going towards more sick time. And once that gets up to 30, you got to give an additional hour. So you can front load based on estimate, but you got to keep track of actual hours worked and supplement if the employee works more hours than expected. So that makes it a little trickier if you want to front load part time, but it's available. So that raises the next question: is can you front load some and not others? And the answer to that is yes. You can front load for full time and accrue part time if you want. You can front load for full time and part time that generally work at least 20 or 30 hours or wherever you want to cut off. So you have discretion as long as you do it within similarly situated employees. So by category of employee, you can front load some and accrue others.
Mike, there's a question here about the cap.
Uh-huh.
Um, So they're asking, how does the cap work with FMLA? Why wouldn't you let an employee use all of their available sick leave? So if someone has accrued more than the 72 hours and then needs to take FMLA, which, can go for 12 weeks, why wouldn't you let them take everything that they've accrued?
You can run, and the FAQ has a specific provision on that dealing with FMLA, but you can run, allow the employee to run sick time with FMLA. The question is can you require it? Because, and we're getting a little outside ESTA
Mhm,
here because the
mhm,
FMLA is a different law and there's a
mhm,
DOL uh, uh, guidance or an opinion letter
mhm,
on this point.
mhm.
But you can allow employees to use ESTA to um, run concurrently with FMLA if both the library and the employee agree to it. If the employee says no, there's a question as to whether the library can require it. There's a Department of Labor opinion letter that says you cannot force uh, paid time. And, that's just paid time. It could be disability. You cannot force running concurrent paid time under the FMLA. So if there's an FMLA, you got to take a look at that. And this is really a nuanced area that you really do need to work with your
Right.
employment attorneys. But the simple answer is you can allow it, you cannot require it. But if it is simply can they use sick time? They're on FMLA. Can they get paid through sick time? The answer is yes. And can you run that concurrently as FMLA time? The answer is yes.
And and I think part of it too is if they have more than 72 hours or 40 hours, depending on the employer size, um, in their bank, the employer can decide to let them use as much leave as the employer permits them to use, right? The employer can decide you can bank more leave than the law says you have to.
That is correct. The 72 is a floor. It's not a ceiling. I would be a little bit careful in setting the cap in the bank as to how it's being used. I think you're in
Right,
a little bit of a slippery slope there.
right, right. I agree.
Okay, and we talked here about the combined PTL being permitted. So we already addressed that. So why don't we go to the next slide? Okay, and this slide, we already had the one question, but let's just work
Mhm.
through it. There's a number of issues here. So, who is an employee? Originally, as I said, an employee is everybody except those who work for the US government. And that is still in there, but they expanded it a little bit. Um, and the additional exceptions that they now allow is unpaid interns or unpaid trainees. And the reason why they added those in, and I think this was done at the wage and hour division's FAQ level, the reason why they are included is not being employees under the exception is you're unpaid. So if you're unpaid, you're not an employee. If you're not an employee subject to taxes, you're exempt from ESTA. So, and I don't think it's just limited to the words interns or trainees. That's what the FAQs say. But if you're not an employee, if you're unpaid, there's no obligation to deduct or for the employee to pay taxes because you're not earning wages, then you're not going to be an employee under ESTA. Uh, Minors, I've actually had several questions on minors and do minors, and this is probably an issue for a lot of libraries. You have somebody under 18, do they get sick leave? And the general answer is no. Minors are excluded, but the caveat here, or I guess the nuance here, is that, and it's probably not an ESTA issue. It's the statute specifically says minors that are employed in accordance with the Youth Employment Standards Act. So I think that was intentional because minors, even if they're volunteers, are supposed to have work permits. And when they get their work permit, then all of the restrictions written into the Youth Employment Standards Act apply to, and that gives some safety and regulatory controls over the employment of minors. So if you get this issue and you say I have somebody 16, 17, and they're working at the library and they're not volunteers, so they are getting paid, do they get sick time? The answer is probably no, but make sure you're in compliance with the Youth Employment Standards Act, because if you don't have a work permit in place, you now may well have a problem with compliance with two statutes, not one. And the next point I want to cover, and we already had that question, I said I'd address it in a little more detail, and I'll do that now. Written specifically into the exemption, and this was a last second change, said an individual who worked in accordance with a policy that allows the individual to schedule their own working hours. So that, at first blush, appears to be a pretty broad exception. But the wage and hour division, at least, takes the position that it's just the opposite. It's a very, very narrow exception. And the statute puts a couple of requirements on it. If you have an individual that works, that can schedule their own hours, it has to be by policy, and that policy has to prohibit the employer, in this case the library, from taking any adverse action if the individual doesn't schedule enough hours or any hours. So you might see this with on-call employees. The question is, if we have available jobs, we have available work, we'll just post it. We'll send out emails, blast them out to anybody and everybody that is on the list. And if they want it, let us know. And the first one, the first three, the first five that respond, whatever the case may be, it's yours. You can get it. And so you have these lists, you have these opportunities come up, and the people can take them or not take them. Is that scheduling their own hours? The wage and hour division says no.
Mhm.
And the reason why no is a few things. First of all, when those opportunities become available is under control of the employer. And if you have on-call employees that never call, is that going to get them off the list and not be available for calls later? The answer to that is yes, you can't use it. So if the employer determines when the work becomes available or has any control over whether the employee stays on the on-call list, if they never ever accept any jobs, the exception is not going to be available. So who is it available for? And according to the assistant director of the wage and hour division, it's very, very narrow, and it's designed primarily for highly compensated employees or maybe owners that can come and go, do whatever they want. They're not subject to any requirements, any scheduling. Nobody can do anything about it. If they work, they don't work. That's what they were thinking. The legislature was thinking. It's a very, very high level. So I don't think the regular on-call employees that a lot of people were hoping it would cover, the wage and hour division says no, that doesn't fit. We don't think that's what the legislature was intended to do. And then another question that I actually have been watching this since the Supreme Court decision, and I'm glad the way it came down. I thought it should, but that was what do you do with elected officials and for libraries, board members, whether they're elected, appointed, or whatnot. The original definition said that you perform services in the interest of the library. That, by interpretation, would cover everybody, including board members. But the wage and hour division says no, that was not, in our opinion, what they intended. So publicly elected officials, board members, commission members, committee members, if they're board members, not employees, or any similar public officers or office holders, are not going to be employees under ESTA unless, and this is, unless you have to pay attention to, but unless they are paid in addition to their regular stipend, if I can call it that, because board
Mhm.
members and libraries get paid, not much, admittedly, but they get paid a little bit for being board members in some libraries. The wage and hour says that's okay. That doesn't make them an employee. But if that person can also do something for the library as an employee, and there might be a conflict of interest here, so let's leave that out for a minute. But if they are a board member and they also have a job with the library, just because they're a board member isn't going to keep them from maybe being considered an employee. So you got to pay attention to the detail. But for the most part, your board members are not going to be considered employees for purposes of sick leave. Now, on the waiting period, the front loading has a lot of what I call pros and cons. The pros of having the front loading is you don't have to track the time towards accrual. You don't have to carry over the unused time. The con, or the opposite side of that coin, I guess, the quid pro quo, is that what you lose if you front load is the waiting period. If you front load time, whether it's for the small employer or the regular employer, it doesn't matter. If you front load the time, so you don't have to carry over the 40 hours or the 72 hours, what you give up is you cannot wait for 120 days for them to use it. So the front loaded time must be made available immediately. And you step back and you think, okay, what are they thinking here? And, it is, I think, a trade off. But then you have new employees, you don't have a track record with the employee. So you now give them 72 hours of sick time, um, you know, in the first 2 months. They're seldom there. And lo and behold, they take, 40 hours of that time they're not showing up as sick time, and then they leave. Is there anything you can do about it? And the wage and hour division says, yep, there is something you can do about it. What you can do is if they leave, you can't apply the 120-day waiting period. You have to allow that time to be available immediately. But if they then leave and they've used all or some of the available sick time, and they would not have accrued that had they stayed, then you can recoup it. But the recoupment comes with a little bit of a difficulty because if you recoup it, what you can do is you can say that you were given 72 hours, you used 40 of it. The amount of time you worked, you would have only earned 20. So we're in the whole 20 hours. We gave you 20 hours you used that you didn't earn. So you owe it back. And you can do that from a legal standpoint, the employee owes it back. The question becomes, and this also gets into a different statute, but the question becomes, what do you do? You can deduct it from their final paycheck, but under two conditions. One, that you don't go below minimum wage under the Fair Labor Standards Act of Michigan law, actually, Iowa. So you can't go under the Iowa minimum wage. And any deductions from pay, including this deduction, which is statutory under ESTA, it's still the requirement under the Michigan Wages and Fringe Benefits Act applies. And what that says is that you have to get a written authorization at the time that deduction is made, signed by the employee. And so you have to go to the employee and you have to say, you owe this 20 hours back. Please sign this authorization form. If the employee says no, then your only recourse, even though they owe it, is probably to sue them in small claims or take some action against it. So you always got to remember when you're deducting wages out of checks to comply with the Wages and Fringe Benefits Act. So that gets us to the wage rate. What wage rate do you use? And there was, I think, a lot of discussion early on. I'm not really sure why, because the regular rate is fairly well known under the Fair Labor Standards Act. But the rate is just that. The rate is the higher of the employee's normal hourly wage rate of the base wage. So whatever they get as an hourly pay or a salary, that's what they get, or minimum wage. So it can't go below minimum wage. So it's generally going to be their hourly rate. It does not include the overtime pay, holiday pay, bonuses, anything like that. So you don't have to worry about every uh, compensation that was provided to the employee, unlike under the Fair Labor Standards Act. Sometimes you have to include all compensation for purposes of calculating overtime. They simplified this. They said none of that counts towards ESTA. It can just be the hourly rate. And if you pay that, as long as it's at least minimum wage, which better be, then yeah, you should be good. So that gets us to the notice requirements. There were some changes here as well. For the foreseeable, there was no change. It's still 7 days. If it's unforeseeable, somebody gets sick before uh, their their scheduled shift comes up, before the last minute changes, there was nothing the library would be able to do about that. This change gives the library some help here because if it's unforeseeable, the notice can either be as soon as practicable, which was the original standard, or the library can have a policy on what's required to call in sick. And as long
Yeah.
as that policy is in writing and is given to the employees before they need to take sick leave, then that policy can be enforced. Even if it, and you see sometimes, at least an hour before, at least, 2 hours before, you can still do that if you have the policy in place and you give each employee a copy of the policy. If you don't have that policy handed out to all the employees, then it's going to be as soon as practicable. So that gets us into the documentation. So now you know that the employee gives a notice, whatever the notice is. They take sick time. They use 3 days consecutively. One of the changes that was made in the final version is the original ESTA just said you can't get any medical documentation unless it's at least 3 consecutive days. And then after that, the library can require it. This statute, or the final version of it, put in a time frame in there. You can say you must provide the medical documentation, and once that's done, the employee has to provide it within 15 days. If they don't do that, then you can't delay taking the sick time, but you can not provide any further sick time after that deadline is not met. So that 15 days is new. What's not new, and it's still in there, is that the penalty for uh, requiring medical documentation is you have to pay the out-of-pocket expenses incurred by the employee in getting the doctor's note. And generally, at least for employees that are insured, the out-of-pocket expenses are going to be the copays. So if you require the medical documentation, the employee has to go to the doctor. The doctor charges them the copay in order to get the documentation signed by the doctor. The library is going to have to pay for that, and that's still in the statute. And then last on this slide is you even though there's no capping of accrued time. Again, we talked about capping the use and the carryover, but just the accrual of the time, uh, even though it's uncapped, once a person leaves, it doesn't have to be paid out. So if the person doesn't use any and they accrue it, they don't use it, and whatever was in there, they leave, the library does not have to pay it out. But the exception is that if the person leaves, and it doesn't matter if it's a termination, voluntary quit, probably wouldn't apply in a retirement, but a termination or a resignation, and then the person comes back, if they come back within 2 months, that sick time has to be reinstated. ESTA, before these final last minute changes, that was 6 months. So if you have an older policy, or if you're on the internet and you see a policy and it says 6 months, that's been changed. It's now a 2 month requirement. Okay, Lana, let's go to the next slide.
Okay, we have a couple questions in the chat. Do you want
Okay, you want to
to?
do that now, or you want to
Sure,
finish the slide?
up to you. Um,
We can address them.
okay. Um, so there's a couple. I'm going to do this one first. We front load sick time more than 72 hours a year. Can we allow carryover each year, but cap it at 800 hours? We also pay out a percentage of at retirement, which we do not have to do.
The answer is yes. You can exceed the amount of carryover, and you can. Let me see. I think I have it right here. We front load sick time more than 72. That's fine. Can we carry over each year? Yes. Can we cap it at 800 hours? There's a little potential nuance here. I don't think it'll ever come up, but I'll raise it because I actually was just talking about it yesterday with one of my partners. And let's assume that they had in year 2026. Well, you might have to go further to make the math
Mhm.
work, but in year one, they had 780 hours in the bank. And then they don't use any time. And then the next year, year two, they accrue an additional 72 hours. And you say, we're capped at 800 hours. You've just accrued 72, but there's only 20 more hours of space available in our bank before it's capped. So the question becomes, is that allowed? Because are you preventing the carryover of 72 hours that year? Um, I could see that possibly being an interpretation that's given. I would argue not, but for clarification, if this ever comes up on the what ifs, I would make it clear that the time that is lost is at the first time that was put into the bank,
Mhm.
not the carryover that takes it over the cap. Because if the cap takes you, or if the new ESTA time, carryover time, takes you over the cap, and that's not allowed, I think that potentially is a violation. So if you have the time lost that was earlier accrued and that the 72 is carried over to get back to the cap, I think that's okay. It's kind of a maybe hyper technical interpretation, but I can see the wage and hour division taking that position.
And I would imagine that even though it's front loading, if you are permitting carryover, there'd have to be some kind of tracking that occurs.
You have to, if you front load, you do not have to track hours accrued
Even if,
because
oh,
you're
okay.
not accruing, but you do have to keep records. And this is also in one of the FAQs,
Even if they're,
specifically addresses that you have to keep records of sick time used and hours worked. Because
so,
if wage and hour comes in, they're going to say, show me your records of all of
mhm.
the hours worked and show me your records of all of the sick time used. And those you have to keep records for at least 3 years. So that's a little different though than tracking accruals.
But if you are going to allow, like normally with front load, you don't have to carry over. But if
Right.
you're going to permit them to carry over, then you still have to track how much people have carried over, it would seem. Even if the law doesn't require it, you're still going to have to do that,
Well,
right?
I think it would be prudent. And for the example we were just talking about, I think they would want to see, are you following your policy? Whether that's an ESTA issue or whether that's a Wages and Fringe Benefits
Got
Act
it.
issue, I think it's probably a Wages and Fringe Benefits Act issue. But
Okay.
if you have a policy and you say, I did it this way because of the policy, under the Wages and Fringe Benefits Act, your policy is enforced as written. So it's going to be, you're going to have to show what your policy is and how you complied with it.
Okay. And then we have a question here from Sarah at Bath, and I may ask her to unmute because the question is, do we have to provide written documentation if it is for vacation time, sick time in a separate bank? And I'm not exactly sure what she means by that. So Sarah, can you unmute and explain?
Yeah, so there was talk earlier it was discussed that if goodness, um man, now I'm having trouble talking. For ESTA, if we are front loading the sick time in the beginning, that we have to provide written documentation that we're expecting you to work this many hours, so this is the amount of hours that are being front loaded. If we do an accrual base for sick time, but our vacation time we decide to front load, do we need to in order to follow ESTA, do we still need to do the written documentation? This is the amount of hours we are expecting you to work, so this is the amount of vacation time we're front loading.
Well, let me ask you I think the most important question here is, do you have one bank or two banks?
Two banks. One is for sick time, which we wouldn't front load, or what I'm thinking we might do is not front load. And then vacation time uh is separate. The sick time we have it written so it follows ESTA. We had it looked over before the changes, but um so basically we would take the time that would be accrued from under ESTA would be in the sick bank, and then the vacation time would be just vacation hours.
Okay, no, that's fine. If you keep the bank separate, and the time for the sick bank, if you will, complies with ESTA, the vacation is not going to uh, have ESTA issues to it. That it might have Wages and Fringe Benefit Act issues to it, but it's not going to be an ESTA issue. But yet you can't consider the vacation time then for compliance with ESTA. So you're going to have to make sure that your estimate of sick time is based on the hours expected to be worked. The 1 hour for every 30 hours worked. That's your how you're going to calculate out what goes in the sick bank. And you cannot, say, well, we already provided some vacation time, so the difference we'll put in the sick bank. That you can't do. The calculation of the time in the sick bank has to be a separate calculation based on ESTA.
Okay. And then we
If
have
that
one.
answers the question, I don't know if I did.
Then we have
Yeah,
one more.
it was answered. Thank you.
Okay, thanks, sir.
Um, we have an employee who holds two different positions within the library with two different pay rates. They only work 2.5 hours a week in the position with the higher rate, and the majority of their weekly hours, 23 per week, are at the lower rate. Do we have to pay their sick time at the higher rate?
Well, I guess the question is going to be in this situation. That's a good question. Let me think this through a little bit because you're not going to put in sick time separately based on what they were paid. This is going to come on what do you have to pay out at. And if you pay out at the regular rate, or normally your regular rate is your hourly rate. So here you have different hourly rates. So I think that the way you're going to want to do this is treat it as you would under the Fair Labor Standards Act, which you have two different positions, but for the sick time, you have 1 hour. It's not, you're not going to track an hour at one rate and a different hour at a different rate. That's not how this is going to be done. It's you're going to have X number of hours in there, and when they leave or when they use it, I guess is the way to say it. When they use the sick time that's in the bank, what do you have to pay out? And I would use the regular rate, and you calculate the regular rate. You take a period of time that whether it's the immediately preceding pay period or month, you have to have a period of time that's representative and figure out what they would work combined, and then how many hours of work. That'll give you the regular rate, and then I would pay out at that regular rate.
Okay, that's all the questions right now.
All right, and then if we
So
get
move to the
into
next one.
the issue of this is really the issue of what happens if there's somebody that feels that there was no compliance or that you didn't do it right. And there's this one of the big changes. It's the second bullet point here is the original ESTA right up until the last minute changes had a private right of action. And I think Claire, we talked about this a little bit at
Hmm.
one of the directors' monthly meetings. And this was one of the big sticking points. And the concern was that mistakes that were made in administering ESTA was going to result in class action litigation in courts, or people are going to go into court and the library is going to be dragged in on lawsuits or whatnot. That has been stricken. So now, if an employee feels that there's a problem, they can go to the wage and hour division, they can file a complaint, and then the wage and hour division will investigate it and determine if they think there's a violation, which is basically what we have now under the Wages and Fringe Benefits Act. If somebody feels that they weren't paid properly, wage and hour looks at it, and then they come in and if there's a mistake, they correct it. The wage and hour division has said that at least while everybody's still trying to figure out exactly what this law means, some of the nuances, some of the gray areas, I don't think they're going to come down and just look for as many penalties as they can impose on libraries. I don't see that happening. I think what I can expect is they're going to look if they get the charge, the complaint. I think they're going to look for a few things. They're going to come in and they're going to say, "Did you post the notice?" If you don't post a notice, I think there's going to be an issue because that means you're either got your head in the sand, you don't care, or you, for whatever reason, you're intentionally not paying attention to the law, and they're not going to like that. So you got to make sure you got the notice posted. Then they're going to look at do you have a policy in place, on what's required. And that's when your policy may be looked at. Is this in compliance? Is it not in compliance? If wage and hour looks at the policy and they say, okay, I see where you got that from, but we disagree. We don't think that's the right interpretation. Wage and hour, at least now, I think, is taking the position that we want to work with you. We want to make sure that everybody comes up to speed, and we think that it should be this way. And as long as you change it, work with us, we'll work with you, type of thing. I expect that to be sort of the enforcement for a little bit. If you don't like the wage and hour interpretation, you can challenge them. But what they're going to do is they're going to send it for enforcement, and then you're going to end up in the courts. So but I don't think wage and hour is going to be real heavy-handed, at least at the beginning. I think they're going to look for compliance. So with that, again, posting the notice, making sure that you have whatever it is that you're doing, that you have the policy covering it. And the policy, there's a lot of discretion the way ESTA is written. That's good or bad. Some people say, well, give me a piece of paper that I'm in compliance. Well, it's not that easy because there's too many variables. Do you front load? Do you not front load? Do how are you going to carry this out? What's the notice requirements? If it's more than practicable notice, what's the written document? Those are the areas where your wage and hour is going to say, you have the policy now. Show me the where how the employees knew about this and how you administered it. And then what we just talked about, the record keeping. Show me the hours worked. Show me the documentation on the sick time used. If you're on accrual, show me the accrual documentation. That's what wage and hour is going to look at if they come in. Now, the one thing where I think the wage and hour is probably going to be a little more concerned about is that if they see adverse action taken, that I think they're going to look at a little more closely. And there's a retaliation provision written into ESTA that says any adverse action taken because of use of sick leave originally was presumptively illegal. And there is a lot of concerns. So somebody takes sick leave, then something happens. They get reprimanded, they get suspended, they get demoted, they get terminated, whatever the case may be. And there's a presumption that was illegal. That presumption was stricken at the last draft. On the 20th, that was one of the last things to go, I think. So, and in its place, the legislature acknowledged that if there's employees that are playing games, if they are intentionally misusing the sick time, or they are deliberately not giving the notice that's required by your policy, the ESTA now says that you can run your business. We understand that you have to run your business. So yes, you can take action if the employee is misusing the sick time or not following the procedures that they're required to follow. But the retaliation provision is still there. So if somebody takes sick time, uses sick time, and then there is some action taken, whether it's a termination or warning or a demotion or whatever, you got to step back and you got to think of what are you doing. And one of the examples I'd like to have you think about, and this is another area where you're going to want to work with your attorney on, but the employee has 72 hours under the ESTA. They use it all. And then they have additional absences. And now it's considered excessive absenteeism. So you're in violation of our attendance policy, you're terminated. Does that violate ESTA? I would be careful with that because the question is going to become, are you using the first 72 hours against them on the determination of excessive absenteeism? And if so, I think it's going to violate the retaliation provisions. So I think you got to be very, very careful on using ESTA sick time for any purposes in a finding that the employee was excessively absent. And the penalties are, $1,000 for every retaliatory action. Again, I don't think Wage and Hour is going to be kind to any employers that retaliate. And then you have the 8 times the hourly wage for failing to provide the sick leave. And the notice posting. This is why I've been harping on the notice posting a little bit. Is $100 for violation of the notice posting. So and I don't think there's going to be a sting operation, if you will, but by March 23rd, that notice is supposed to be up. You could have on the notice posting, somebody could walk in March 24th. You don't have that notice up. That could just cost you $100. So again, make sure that you have the March 7th notice posted. Now let's talk briefly. I don't know how many people is participating in this webinar. Um,
There's about 60.
yeah, but I don't know how many are union.
Oh, mhm.
You have if you have a collective bargaining agreement, that is going to affect some, maybe not all of the employees. So the question becomes, when do you comply? And the answer to that is, if you have a CBA in place for the bargaining unit employees, ESTA does not apply until the collective bargaining agreement expires. And there's two issues though. One is the collective bargaining agreement has to specifically address sick leave or paid time off. If it's silent, then at least the wage and hour division's interpretation is that it's not exempt. You don't have to wait till the CBA expires. It's got to be immediate. I personally have some concerns with that because there's constitutional issues here. You have a collective bargaining agreement, which is a contract. By constitution, statutes can't impede contracts. The wage and hour says, well, if it doesn't specifically address paid time off, sick time, then you're not impeding the contract. But what it's going to do is it's going to require that you address it mid contract. So you have para considerations where it's a mandatory subject to bargaining. So I think there's some real touchy issues here. But if you have a collective bargaining agreement, you need to take a look at it, see if it addresses sick time. If the answer is yes, then you don't have to come into compliance with ESTA until the contract expires. And it's the date written in the CBA that it expires. You can't extend it. You can't say, a year before, let's extend it for another year and go out to delay the date ESTA applies. That would not count. It's the date that's written into the CBA. And I don't know if this is going to affect too many people, but it's potential that there's some individual employment agreements, maybe with the directors, maybe others. Some do, some don't. But if there is an employment agreement that addresses sick time, that also would not need to come into compliance with ESTA for the duration of the contract. But the nuance there is that contract had to have been in place as of December of 2024. Where they got that date, I'm not sure about, but it's in there. So if you have individual employment contracts with any uh, individuals, and I guess this is more for the board because I think most of the people on this webinar are primarily directors. But if there's a individual employment agreement that covers sick time, that also may be something that needs to be looked at closer on whether you come into immediate change immediately because of what's written in the contract versus ESTA. And so I don't know. I think there's too many fact sensitive issues to talk about that in too much more detail, but it's something that you should be aware of is that just because the legislature says that sick leave is now by statute has to be what ESTA says, you can't use that to violate somebody's contractual rights in a CBA or an individual contract. So that's the, I guess, the 30,000-foot view of what the final statute looks like. If you could go to the next slide, Claire, this will give you some of the guidance. The first slide is just wage and hour divisions, general landing page, if you will, their web page. The second bullet point is the statute itself. And this all started with, I think everybody knows, with the ballot initiative in 2018. And that's still the that PA number. It's 338 of 2018. So that's the law. If you're looking for it, it is the it's called the ESTA, Earned Sick Time Act, 338 of 2018, but it's as amended in 2025 by PA2. A lot of numbers, a lot of acronyms, but the reason why I mention that is because it's hard to find. It's very, very hard to find given its history. And if you go into the Michigan legislature page of all the statutes or whatnot, you're going to have the number of different variations of this come up. But I gave you the link on what is the current ESTA that has become law. And then the next bullet point gives you the wage and hour FAQs, which they have updated 2 or 3 times already. Like I said, most recently just a couple of weeks ago. And so those are worth looking at periodically and keeping an eye on, because I think they're still going to be updating them with some additional areas that they have not yet taken a specific position on. So that's worth glancing at. And then the last bullet point gets you into the poster, as I recall. So those are the. If you look at those, it probably gives you way more than you want to know. But I know there's so many people doing so many webinars, and there's so much information that if you just follow through, what we went through today and what Wage and Hour has provided as guidance, I think it'll go a long ways towards complying with this new law. So with Claire, with that said, I think I will ask you for your additional comments, questions, anything else in the chat?
Yeah, there's one more thing in the chat. Hang on, let me go back to it because the notes. Okay. This is someone who joined us a little bit late, which is fine. She says, does the new act address how much sick time can be used by employees? Along with the new rules we were expecting, our HR also added a provision limiting the amount of sick time that can be used in a fiscal year.
Yes, the use can be limited by size of the employer. If it's a small, that's where the 40-hour use limitation comes in. All others, 72. That's on how many hours can be used in a year. The year, the employer can define the year. The statute says it can be any consecutive 12-month period. So it could be a calendar year. The three most common are the calendar year, the fiscal year, or the anniversary year. If it's the anniversary year, then the administration is going to be harder because you're going to have to calculate it based on everybody's date of hire. But I have seen some libraries doing that. But that's the library's choice. So you can use any year as long as it's a consecutive 12-month period, and the use is by year, so you can limit it to the 40 or the 72. Of course, as Claire, we already talked about, it can be increased beyond that, but it can't be reduced below that.
Mhm.
So that is where the use comes from. That's different from the accrual, though. Keep that in mind, but that is use, so that is correct.
And then someone mentions that the poster that you're linking to at Leo says it was updated at last updated February 27th, 25. Is that the most recent?
Yeah, and I might have confused that a little bit because I gave the 3/7. I want to clarify that. The March 7th date is when the wage and hour updated their FAQs to address all this. The one before that, I don't recall exactly when the date was before that, but that was, so if you go into the FAQs, the most recent FAQs you're going to find is March 7th. The February 27th, 2025 poster is the correct poster. And if you want to test that, but that is the right date. But if you look at the enforcement right at the very
Hmm.
bottom of that poster, the mistake they made when they first printed that, they had a couple others in there too, but the biggest mistake they made is they still had in there that was an enforcement was the right to sue directly in court. That was the second bullet point that was still in there. This February 27th poster just has the for enforcement, the filing with the wage and hour division. So if you only have that one bullet point, you got the right poster.
Awesome. Okay. Can Mike clarify again that front loads must have been at 72 hour for full time or a prorated amount for part time as of 2/21? So if an employee was below that due to use, we have to bring them back up to that amount. So I'm guessing if an employee was below that before 2/21, um, they would have, as of 2/21, they would have had to been brought up to that amount.
Yeah, I think there's a further clarification because of the term prorate. And one of the problems with ESTA is I think some of the words that are used have significance that
Mhm.
uh, you know may be unintended, but it's something you have to look at the exact words that are used. And one of them is accrual versus use that we talked about at length. That's an
Mhm.
important distinction in wording. So is prorating. And prorating, you'll see in two different contexts. One is for the initial year of the ESTA, if you use the calendar or the fiscal, what is the year since the ESTA took effect February 21st. And if you use prorating in that context, it's February 21st till the end of the benefit year, June 30th or December 31st. And then after that, it'll be full year. Or if it's for new employees, let's assume that you use the calendar year. So December 31st, you would have prorating from December or from February 21st to December 31st. Then January 1st of 26, the year would end December 31st. If you have an employee hired mid-year, you could also prorate based on the employee's hire data hire. So if the person is hired July 1st of 26, you would prorate for 6 months. So that's generally how prorating is used. In this question, prorating is used in connection with part-time. And I don't know if I would call that prorating because of the way the ESTA uses prorating, or at least the wage and hour division does. That is an estimate of the hours to be front loaded based on the anticipated, the expected hours worked. So the front loading is an estimate of the number of hours worked and sick time given based on how much sick time would be accrued given that number of expected hours. So I think there's a little different context than prorating. So you can front load the sick time based on expected hours of to be worked by the part-time employee. And then the question on if you go below that due to use, you have to bring them back up. That is correct. So I think this is David. Does that answer your question, or do we need to uh, dig deeper into this rabbit hole?
Yes, David says yes.
Okay, good.
Um, and then there's one more question. Can Mike briefly walk us through one more time why substitute librarians are subject to ESTA? So this would be the situation where if you have a list of substitute librarians that you call in if one of the regular librarians who's supposed to work the desk is sick.
Yeah, the question becomes, first of all, are they an employee? And the employee means, do they perform services in connection with the purposes for the library? And are they paid wages for that? And I think that the answer, unless they are volunteers, substitutes do perform services for the library and are paid for it. And that pay is taxable. So they're going to be employees. So as employees, and this is not one of the areas that fits an exception. The only one that potentially could come close to a potential exception would be the exception that allows where employees schedule their own hours. But at least the wage and hour division's position is that is a very, very narrow exception and probably only available to highly compensated
Right,
employees that schedule their own hours, come and go if they want, very, very limited exception.
right. So
If
if
the for the subs, the libraries are going to sort of control when work is available, meaning that there's going to be the employees that don't show up. The library is going to put out a call for subs. There's going to be employees that are available to take that work. And even though the employee can take or accept the invite to sub or not, that is not going to get you into the exception. That's controlled by the library. And if the employee never ever does anything and the library just stops calling them, that's another reason why it would not be covered by the exception. So here you have an employee, you have the library at least with some control over how the subs are called and has the ability to determine who is on the call list and who is not. So those employees are going to be at least, and again, this is a wage and hour division's position, and it's how it's going to be enforced. So they're going to be found to be employees. So when they are working as a substitute, they're going to be accruing time. The harder question here is when they can use it. Because if they finally sub for at least 30 hours, they're going to have 1 hour in their sick bank. But when can they use it? The only time they could use it is, if there's a call for subs and that person would not be on the schedule yet. So they can't use that time before they're actually scheduled. So I think that what wage and hour is going to do here is they're going to say that, and there's actually one of the FAQs has a close analogy to this, is once that call goes out, somebody wants to sub, they accept it, they get put on the schedule to sub, for that day. And then between the time they accept that call and the day where they actually have to sub, they get sick. And then they can't show up because they're sick. They were already scheduled to sub. Then I think they could use that out.
Okay. Well, we're at 3:30. And there's no more questions in the chat for right now.
Hey,
Mike,
timing is everything.
that's right. Mike, thank you so much for joining us. Thank you for doing this for us. We really appreciate it.
Oh, my pleasure. Thanks for inviting me. And if anybody has any questions, feel free to email me. I'll try to answer them. I've been a little bit busy, so don't get mad at me if I don't respond immediately. But I'd be happy to answer any other questions that may come up.
Well, thank you so much. Well, I hope everyone has a great rest of their day. And thanks again, Mike.
Okay, bye bye.
Bye.